Hello and welcome. Thank you for joining our webinar focused on what you need to know about the Pension Schemes Act 2020. This webinar forms part of Mayor Brown's annual pensions conference, which is a series of webinars covering current and upcoming topical matters relevant to the pensions industry. My name is Andrew Block and I'm a partner in Mayor Brown's pensions practice. Joining us today is my colleague Olivia Caird, Senior Associate in the London Pensions team. Together, we will discuss how the new Pension Schemes Act 2020 will pave the way for wide-ranging changes to the pensions landscape and how trustees will be impacted. During this series, we have addressed topics including investment structures and related tax considerations, changes in pension scheme investment compliance and disclosure requirements, pensions litigation, GMP equalisation, covenant and funding in the new paradigm, and effectiveness of trustee boards.
Thank you, Andrew. Good morning, everyone. As Andrew said, my name is Olivia Caird, and I am a Senior Associate here in the Pensions Department at Mayor Brown. We are going to discuss a range of topics that fall under the umbrella of the Pension Schemes Bill today. Although one point to note at the outset is that we are not going to cover the provisions on collective money purchase schemes, as this is a topic for another day. The topics we are planning to cover today are where the bill is in its journey through Parliament, the changes to the scheme funding provisions, the proposed changes to the transfer process, the provisions on pensions dashboards, how climate change risk is being addressed. Andrew is then going to talk through the extensive new pensions regulator powers, and we'll consider what is next for the Pension Schemes Bill and when we can expect it to become law. At the beginning of the year, following the 2019 general election, and recently progressed through the so-called committee stage. This is where members of the House of Commons had the chance to debate on various provisions in the bill and were given a vote on amendments that had been put forward by the House of Lords over the summer. The committee stage has now been wrapped up, and on the 16th of November, the bill entered and completed the third reading and report stage in the House of Commons. This will be followed by consideration of the amendments that have been made to the bill by the House of Lords. The date for this is yet to be set. The next stage after that is royal assent. Guy Opperman, the Pensions Minister, said in September that he is confident that the bill will be law by the end of the year. This is certainly looking like a strong possibility. One point to note is that while the end may be in sight for the Pension Schemes Bill itself, the bill provides for much of the detail to be set out in regulations. Guy Opperman has said that the government intends to consult on secondary legislation after the bill receives royal assent. Turning first of all to scheme funding. These changes are of course not happening in isolation, as the pensions regulator is working on its new scheme funding code, which promises to be quite a shake-up of the current position. But turning to the provisions in the bill, trustees of defined benefit schemes will have a new obligation to decide on a funding and investment strategy to ensure that pensions and other benefits can be provided by the scheme over the long term. Trustees will be under an obligation to keep their strategy under review and update it where necessary. The strategy must specify the funding level which the trustees intend the scheme to have achieved at specific points and detail the investments they intend to hold at such dates. The strategy will feed into other aspects of the current funding regime. For example, the scheme's statutory funding objective will need to be achieved in a way that is consistent with the strategy, and similarly, the scheme's technical provisions will need to be calculated in a way that is consistent with this strategy. We don't have much more detail than this at the moment, as the matters that trustees will need to take into account when producing their strategy are to be covered in regulations, which haven't been published yet. But the bill gives us a hint of what regulations are likely to cover, and these include requiring trustees to take account of certain matters when formulating their strategy. This is currently very vague, but we suggest that, as an example, the regulations might require trustees to consider the scheme's maturity, whether it is open or closed to future accrual, and the financial strength of the sponsoring employer, as factors such as these will affect the timeframe, funding levels, and investments which are held by a particular scheme. The regulations may require certain principles to be followed. Again, this is very vague, although the bill does suggest that trustees could be required to adopt prescribed actuarial methods and assumptions. And the bill also says that regulations may set out the level of detail required in the strategy, how long trustees will have to turn in their strategy, and specify how frequently the strategy should be reviewed. For example, regulations could be used to require trustees to review their strategy annually. This new requirement is backed up by civil penalties for non-compliance, which means the potential for fines of up to £5,000 for any individual or up to £50,000 for any corporate which failed to produce and keep under review an appropriate strategy. In addition, the pensionator will be able to direct trustees to review their strategy if it deems it to be inappropriate. As soon as reasonably practicable, after determining or revising the scheme's funding and investment strategy, the trustees will have to prepare a written statement of strategy. This was the document that was referred to as a DB Chair statement in the Government White Paper. There will be two parts to the written statement. Part 1 will contain the scheme's funding and investment strategy, while Part 2 will cover the following supplementary points. Firstly, the extent to which, in the trustee's opinion, the strategy is being successfully implemented, and where it is not, the steps proposed to remedy the position, which will include details about timing. Secondly, the main risks faced by the scheme in implementing the strategy, and how the trustees intend to mitigate or manage them. And thirdly, the trustees' reflections on any significant decisions taken by them in the past that are relevant to the strategy, including any lessons learned that have affected other decisions or may do so in the future. And fourthly, any other matters that are set out in regulations. As you can see, the potential scope of this second part of the statement is potentially very wide. The trustees will be under a legal obligation to review these 4 supplementary points from time to time, and regulations may set out legal minimum periods for review. An important feature of the funding investment strategy and the written statement is the involvement of the employer. The legislation states that the employer must agree to the scheme's funding and investment strategy, as set out in the scheme's written statement, and must be consulted on the supplementary matters which will be covered by Part 2 of the written statement. This represents an increase in the involvement of employers, as the requirement for agreement to the funding and investment strategy gives employers a seat at the table with regards to investment decisions. By contrast, under the current regime, the Pensions Act 1995 says that neither a trust scheme nor a statement of investment principles may impose restrictions, however expressed, on any power to make investments by reference to the consent of the employer. It is currently unclear how these provisions will fit together and what this will mean for trustees in practice, but on the face of it, this seems like a shift towards greater employer involvement. The statement must then be signed by the Chair of Trustees. Similar to the position in relation to the strategy, we don't have any further information at present on the details of the written statement, but once again, the bill gives us some clues of what to expect. It says that regulations may require trustees to take account of certain matters and follow certain principles when preparing Part 2 of the written statement. Regulations may also cover the detail required and the form the statement should take. And they may require that trustees send the written statement to the regulator. So it is conceivable that regulations might require a statement to be based upon a template, which is submitted to the regulator with the actuarial valuation, which under the bill should be submitted as soon as possible after having been received by the trustee. Similar to the position for trying to ensure compliance with the requirement to prepare a strategy, the requirement to produce a written statement will be backed up by civil penalties for non-compliance. So there is potential for fines of up to £5,000 for any individual or up to £50,000 for any corporate for non-compliance. Moving on now to take a look at the way the bill proposes to restrict transfer rights in order to protect members from the very real threat posed by pension scammers. The bill provides that members may only exercise their statutory right to transfer from an occupational pension scheme or a personal pension scheme if certain conditions are met. The conditions will be set out in regulations, but the bill gives examples of the types of conditions that we can expect to see. Firstly, conditions about the member's employment or place of residence, which is intended to ensure that there is a genuine employment link to a receiving occupational pension scheme. The explanatory notes to the bill suggest that evidence relating to a member's employment could include payslips. Secondly, the member obtaining information or guidance about exercising their transfer rights from a prescribed person. Members will lose the right to take the cash equivalent where the duty on the trustees to make the transfer is extinguished because a prescribed condition has not been met. The details will be covered in regulations which will be subject to consultation. And on this point, Guy Opperman has said the aim will be to strike a balance between thorough consultation and the need to act quickly to offer the maximum protection to pension savers. Here it is very clear that the success of this provision will depend on the details in the regulations. Guy Opperman has confirmed that the presence of certain red flags in a transfer request could potentially bar the trustees from carrying out the transfer. Examples given of possible red flags included where the receiving scheme or parties in the transfer do not have the required permissions from the FCA, where members have been contacted via social media, email or cold calling, or have been offered a free pension review or early access to cash, where there is pressure to transfer quickly, and whether the receiving scheme is registered with HMRC. This could potentially be welcome news for trustees, as it would give them uncontestable grounds for refusing a suspect transfer. But the devil will be in the detail, so we will wait with interest to see how this is addressed in the draft regulations. The PLSA estimates that on average savers will have 11 different pension pots when they retire. The idea of a pensions dashboard is to allow people to see all of their pension pots in one place, which could be a powerful aid to savers' retirement planning. The bill introduces a statutory definition of a pensions dashboard service, which is an electronic communication service by means of which information about pensions may be requested by and provided to an individual or a person authorised by the individual. As well as covering commercial dashboards, in addition, the Money and Pension Service will develop its own dashboard service. To be a qualifying dashboard, it will need to meet requirements that will be set out in regulations to ensure that the service meets certain standards before schemes are required to provide information to it. In particular, these may relate to how the dashboard is set up, maintained and operated, and the information that is provided about private and state pensions. Qualifying dashboards will also need to meet certain standards and technical requirements, and there is likely to be a requirement for the provider to be approved, especially given that being a provider will be a new regulated activity under the Financial Services and Markets Act 2000. There will be a statutory obligation on trustees to provide pensions-related information to qualifying dashboard services and the dashboard set up by the Money and Pension Service. This information will be prescribed by regulations, but might include the constitution of the scheme, the administration and finances of the scheme, the individual's rights and obligations that arise or may arise under the scheme, their entitlement to pensions and benefits, and the position of the individual in relation to the scheme. Regulations will also be expected to cover the circumstances in which information must be provided, the form in which information must be provided, the time in which information must be provided, and the steps to be taken before it is provided, such as ID verification. Regulations may also require trustees to comply with standards, specifications, or technical requirements published from time to time by the Secretary of State, the Money and Pensions Service, or another person specified by regulations, as well as have regard to guidance published by the Secretary of State or other person specified by the regulations. Furthermore, trustees may also have obligations to provide information about the carrying out of their duties in relation to pensions dashboards to the regulator, the Money and Pensions Service, or another person specified by the regulations. There are specific provisions that mean that provision of information to a qualifying pensions dashboard service or the Money and Pensions Service will not breach any duty of confidence or any other restriction on the processing of personal data. Compliance will be enforced primarily by the pensions regulator through the use of compliance notices, penalty notices, or through other functions conferred on the regulator. Once again, financial penalties are capped at £5,000 for individuals and £50,000 for corporates. There has been some toing and froing on this topic as the bill has progressed. 2 House of Lords amendments were recently reversed at the committee stage in the House of Commons. The first was a prohibition on pensions dashboards, including a facility for engaging in financial transactions. One of the reasons for removing this restriction is that it is hoped that dashboards could be used to encourage consolidation of members' small pots. The second House of Lords amendment, which was removed, was a requirement for the dashboard developed by the Money and Pensions Service to have been in place for at least a year before commercial providers were able to operate. But this was rejected on the grounds that consumers would be best served by having a choice of providers, and this would encourage innovation in this space. It is clear that the provision of pensions dashboards is going to be a big undertaking, both in terms of developing the technology, the number of parties involved, the governance of the whole process, as well as the requirements for the provision of data, which will ultimately fall on administrators. In an update from the group responsible for designing the dashboard infrastructure, the Pensions Dashboard Programme, set up by the Money and Pensions Service, it is expected that mandatory onboarding to pensions dashboards will take place from 2023. It is expected that there will be a phased approach to onboarding, and it seems likely that large DC schemes will be among the first schemes to be subject to the requirements, with the whole process of onboarding taking 3 to 4 years. Climate change is a growing and important area for pension schemes, and one that is firmly on the government's legislative agenda. On the 11th of February 2020, the government tabled amendments to the bill which will grant the DWP regulation-making powers to impose requirements on trustees with a view to ensuring that there is effective governance of the scheme with respect to the effects of climate change. The effects of climate change include in particular the risks from steps taken because of climate change and opportunities relating to climate change. The examples of new regulation-making powers that are set out in the bill seem to focus mainly on the risks to schemes and could include requirements to review the scheme's exposure to climate risks, determine a strategy to manage that exposure, determine and measure performance against targets relating to the scheme's exposure to certain risks, and prepare documents and publish prescribed information on the effects of climate change on the scheme. Trustees may also be required to assess their scheme's assets by reference to their exposure to certain risks and consider their contribution to climate change. Climate change is not a static concept, and as such, there are likely to be requirements on trustees to consider how it might change and consider different steps that might be taken because of climate change. In particular, regulations may require trustees to adopt assumptions about the steps that might be taken towards achieving the Paris Agreement climate goal or any other climate goal. The new provisions will apply to all occupational pension schemes, both DB and DC, though they are likely initially to be limited to larger schemes. In formulating its approach, the DWP plans to balance what it describes as the urgent need to consider climate change risks in the scheme governance process against business requirements, which may take time to implement, such as updating systems and preparing data. The bill also provides for the DWP to be able to issue guidance which trustees would have to have regard to when complying with the requirements. Regulations are also likely to include provisions for the regulator to have power to issue compliance notices and penalties for non-compliance, with financial penalties being limited to £5,000 in the case of an individual or £50,000 in any other case. The recent DWP consultation on taking action on climate risk and improving governance and reporting by occupational pension schemes gives us a further indication of what regulations made under the bill are likely to cover. The consultation closed on the 7th of October 2020. As well as applying to occupational pension schemes, the consultation proposes the requirements will apply to all authorised master trusts and all authorised collective money purchase schemes. While the timing of requirements will be staggered, depending on the size of the occupational scheme, ultimately it is proposed that schemes will need to put in place effective governance, strategy, risk management, and accompanying metrics and targets for the assessment and management of climate risks and opportunities. For the largest schemes, with £5 billion or more in assets, this would apply from October 2021. This will involve calculating the carbon footprint of the scheme and assessing how the value of the scheme's assets or liabilities would be affected by different temperature rise scenarios, including a Paris Agreement compliance scenario where temperature rises are limited to well below 2 degrees C. Schemes will be expected to publish climate risk disclosures with a mandatory fine for failure to do so set at a minimum level of £2,500. This is referred to as a TCFD report, referring to the industry-led task force on climate-related financial disclosures. The report would need to be made publicly available via the scheme's annual report and accounts, as well as being published on the scheme's or the sponsor's website. For the largest schemes, this requirement would apply within 7 months of the end of the scheme year that is underway on the 1st of October 2021, or by 31st of December 2022 if earlier. In addition, schemes will be required to report the greenhouse gas emissions of their portfolio. Initially applying to occupational pension schemes with £5 billion or more in assets, master trusts, and collective money purchase schemes, the governance and reporting obligations will then be extended to schemes with assets of £1 billion or more from 2022, with a plan to extend requirements to all occupational pension schemes in 2024. Thank you all for listening. I'm now going to hand over to Andrew.
Thank you very much, Olivia. So for the second half of the talk, we're going to look at the pensions regulators' new powers. Their new powers in relation to criminal offences, new powers to issue a financial penalty, new circumstances in which they can issue a contribution notice, and new notifiable events. We're not going to look at the regulators' new information gathering powers. These are a topic in themselves and therefore another day. So let's start by looking at the pension regulator's existing powers. They're listed on the slide. The one I want to focus on is contribution notice. Just to recap on what the contribution notice is, it's a notice the regulator can issue if there's been an act or failure to act which has detrimentally affected in a material way the likelihood of accrued scheme benefits being received. And the regulator has issued a code of practice which fleshes this out to include sponsor support being removed, being substantially reduced, or becoming minimal. There is a statutory defence to the material detriment test, which is that the defendant gave due consideration to the extent to which the act or failure might detrimentally affect in a material way the likelihood of accrued scheme benefits being received, and made all the inquiries and actions that a reasonably diligent person would have made in the circumstances, that they took all reasonable steps to eliminate or minimise the potential detrimental effect, and it was reasonable to conclude that the act or failure would not be materially detrimental to the likelihood of members receiving accrued scheme benefits. The other criteria are that the scheme must be a defined benefit occupational pension scheme, the target was a party to or knowingly assisted in the act or deliberate failure to act, it occurred within the last 6 years, or the target was an employer or was associated or connected with the employer between the act occurring and the issue of a warning notice, and it was reasonable to require the target to pay the sum specified in the notice. Now, this becomes important because, as we'll see, the regulator's new powers tie around its existing powers in relation to being able to issue a contribution notice. Just before we get onto the new powers, just some history to put them into context. The background to the regulator's new powers is, of course, the collapse of BHS in April 2016. It was previously sold by to Retail Acquisitions Limited, owned by Dominic Chappell, for £1. There was no regulator clearance. In March 2016, BHS went into a CVA. The Work and Pensions Committee became involved, and Sir Philip Green ultimately put £363 million into the scheme. The regulator made a contribution notice of £9.5 million against Dominic Chappell, and the Joint Work and Pensions and Business Innovation and Skills Committee of Parliament produced a report which recommended stronger powers for the pensions regulator on the back of the BHS case, and the result ultimately was the provisions that we're looking at in the Pension Schemes Bill. What this means is the criminal offences and powers we're about to look at are the result of parliamentary scrutiny and the report of a parliamentary committee, and they're not the report of TPR directly asking for them. In other words, the pensions regulator may be about to be given powers that it doesn't particularly want, but with an expectation in Parliament that it uses them. So the Act contains and creates a new criminal offence of avoiding employer debt, a new criminal offence of risking accrued scheme benefits, certain other new criminal offences, which we will come on to. It widens the circumstances in which the pensions regulator can issue a contribution notice, and it gives the pensions regulator the power to issue a civil penalty of up to £1 million where there is avoidance of employer debt, and that is in addition to a contribution notice which would require the recipient to pay money to the pension scheme. In addition to the criminal offences, the regulator has been given a new power to issue a financial penalty if there's avoidance of employer debt. The slide contains a quote from the legislation. The regulator can issue a financial penalty of up to £1 million against a person who is a party to an act or deliberate failure to act, the main purpose, or one of the main purposes of which, was to prevent the recovery of the whole or any part of a statutory debt, including a contingent one, to prevent such a debt becoming due, to compromise or otherwise settle it, to reduce the amount of such a debt if it was not reasonable for the person to act or fail to act in the way that the person did. The legislation specifically catches preventing a scheme failure notice or a cessation notice from becoming binding, but it doesn't cover anything done by an insolvency practitioner. So anything an insolvency practitioner does will be excluded from the risk of having a financial penalty issued against them. As you can see, it expressly includes a series of acts or failures to act, and it also expressly covers those who knowingly assist in the act or failure. And knowing assistance, there's a series of case law which makes it clear that that includes turning a blind eye and not asking the obvious question. So to look more closely at the new criminal offence of avoiding an employer debt, and again, the quote from the legislation is on the slide, person commits an offence only if They do an act or engage in a course of conduct that prevents the recovery of the whole or any part of a statutory debt, including a contingent statutory debt, prevents the debt becoming due, compromises or settles it, reduces the amount of such a debt. They intended the act or course of conduct, and they did not have a reasonable excuse. Again, the legislation specifically catches preventing a scheme failure notice or a cessation notice from becoming binding, and again doesn't cover anything done by an insolvency practitioner. And the maximum penalty is an unlimited fine or 7 years imprisonment. Prosecutions for breaching for this criminal offence require the consent of the Secretary of State or the Director of Public Prosecutions. And what that means is that individual pension scheme trustees or trustee boards cannot start private prosecutions under this legislation. So alongside the new civil penalty and criminal offence for avoiding scheme debt, there's also a new civil penalty and criminal offence in relation to conduct risking accrued scheme benefits. Now, the regulator can issue a financial penalty of up to £1 million against a person who was a party to an act or deliberate failure that detrimentally affected in a material way the likelihood of accrued scheme benefits being received if the person knew or ought to have known the act or course of conduct would have that effect, and it was not reasonable for the person to act or fail to act in the way that they did. Again, this doesn't cover anything done by an insolvency practitioner, and again, it includes a series of acts or failures to act, and also includes those who knowingly assist in the act or failure. So it's very widely drawn. And as with employer debt, there's a criminal offence sitting alongside the new power to levy a civil penalty. A criminal offence of conduct risking accrued scheme benefits. If a person does an act or engages in a course of conduct that detrimentally affects in a material way the likelihood of accrued scheme benefits being received, then you ought to have known that the act or course of conduct would have that effect, and they did not have a reasonable excuse. Again, insolvency practitioners are excluded. Again, it includes course of conduct. It includes knowingly assisting. And the maximum penalty is, as with the other criminal offence, an unlimited fine or 7 years imprisonment. And as with the criminal offence of avoiding scheme debt, prosecutions need the consent of the Secretary of State or the Director of Public Prosecutions. So just some thoughts on the new powers to issue civil penalties and powers to bring prosecutions. The regulator has got a twin-track approach here. It will have the choice of either pursuing a criminal prosecution or a civil penalty, or both. And presumably what it will do is use the threat of criminal prosecution to secure better outcomes for a scheme than it would otherwise be able to achieve. The reasonable excuse wording is interesting. The concepts of what a reasonable excuse will probably be imported from the existing approach to contribution notices. But in a contribution notice, the person who is on the receiving end of the notice has to show that they have a reasonable excuse, so the burden of proof passes to them. But in a criminal context, it would be for the prosecution to prove beyond reasonable doubt that the defendant did not have a reasonable excuse. The power to issue civil penalties is wider than that for contribution notices because you don't have to show association or connection. Criminal offences require knowledge, and it's going to be interesting to see how that plays out in court. The prosecution will have to show beyond reasonable doubt that the defendant intended or knew or ought to have known that the course of conduct would have the effect that it did. And what does ought to have known mean in a criminal context? What's the standard? And again, this is different to a contribution notice, where a person has a defence if they can show on the balance of probabilities they've taken all reasonable steps. So prosecutions for the criminal offence will be before a jury in a Crown Court, and the judge will have to give the jury written directions on the elements of the offence and will need expert evidence to do so. The jury will then decide if those elements are made out beyond reasonable doubt. And we think that jurors may struggle to understand some of these concepts, especially in the pensions context. What this means is the regulator is likely to prosecute only where they think that the jury would find the conduct to be criminal, as opposed to people doing their best but simply falling foul of what is a fairly complicated piece of legislation. The prosecutions could take years, and this will be a problem for advisors and for employers and companies when faced with a regulator's threat to prosecute. It's not much of a comfort to a client if you're able to tell them not to worry, because in 2 years' time, when a case gets to a jury, the jury is most likely not to convict them. The regulator, of course, knows this, And this brings us back to the twin track approach, where they will probably use the threat of criminal prosecution to try and secure better outcomes for the fund than would otherwise be the case. When deciding whether or not to prosecute, the regulator is likely to apply the two-stage test that Crown prosecutors use. The evidential test, on the evidence before the jury, is it more likely than not that the jury will convict? And the public interest test, is it in the public interest to prosecute? It is likely that the regulator's approach to prosecution will be similar to the FCA's approach to prosecution under the financial services legislation, not least because the pension regulator's head of enforcement is ex-FSA. What this means is it's more important than ever to document decision-making, because this will be the evidence that you will use to show that you have a reasonable excuse to do what you did. The Act also widens the circumstances in which the regulator can issue a contribution notice. Now, as opposed to a civil penalty, this is a notice requiring a payment to be made to the pension scheme, as opposed to effectively a fine to be paid to the regulator. So the new circumstances are that the scheme is in deficit on a buyout basis. There is an act or failure to act that would have materially reduced the statutory debt had one been triggered. And there are some statutory defences. The defendant took all reasonable steps to eliminate or minimise the potential for the act or failure to act, or the defendant gave due consideration to the fact that the act or failure to act might materially reduce the statutory debt, having made inquiries that a reasonably diligent person would have made in the circumstances. And having regard to all the circumstances at the time, it was reasonable for the defendant to conclude that the act or failure would not materially reduce the amount of debt likely to be recovered. And because we're back in the civil world, this is a test on the balance of probabilities. So the regulator would have to show on the balance of probabilities that the act or failure to act would have materially reduced the statutory debt. And then the person against whom the regulator wants to make the contribution notice to make out the statutory defence would have to show on the balance of probabilities that one of those statutory defences is made out. There is another new circumstance in which the regulator can issue a contribution notice, and that is if there's an act or failure which reduces the value of the resources of the employer, and the reduction is a material reduction relative to the estimated statutory debt in relation to that scheme. And there are the same statutory defences as for the previous widening of the contribution notice. Legislation already contains a list of criteria which the regulator needs to consider when deciding whether it is reasonable to issue a contribution notice. These are a non-exhaustive list. But the new legislation adds to that list in that the regulator can take into account when deciding whether or not it's reasonable to issue a contribution notice a failure to provide information that the regulator has asked for. There is a new criminal offence and civil penalty for failing to comply with a contribution notice, that is, failing to pay into the pension scheme the amount stated on the contribution notice. The criminal offence is a summary offence prosecuted in a magistrate's court, and the maximum penalty is a £5,000 fine. And as with the other criminal offences, prosecutions can only be initiated by the Secretary of State or by or with the consent of the Director of Public Prosecutions. The regulator can also impose a civil penalty of up to £1 million, and that's in addition to the trustees being able to sue for the amount of the contribution notice as the debt. The regulator also gains a new power to issue a financial penalty for providing false or misleading information to the pensions regulator or to trustees. It's a civil penalty of up to £1 million for knowingly or recklessly providing the regulator or trustees with information which is false or misleading in a material particular, where either legislation requires the information to be given, or the information was provided in circumstances in which the person providing the information intends or could reasonably be expected to know that it would be used by the regulator or used by the trustees, used by the regulator in the exercise of its statutory functions. The legislation also extends the list of notifiable events. These are events that have to be notified to the regulator, and they're not indicative of any wrongdoing necessarily. They're just simply things that happen where the legislation says that you need to tell the regulator. The regulator will require certain business transactions to be notified it and to the trustees of a pension scheme in advance of those transactions happening. Details of exactly what that means and which transactions will be caught haven't yet been published. Well, that was a very quick canter through some of the new criminal offences and powers that the Act creates and gives to the pensions regulator. As Olivia said, we expect the bill to receive royal assent before the end of 2020 or at the beginning of 2021. Much of the detail in the Act is going to be in secondary legislation which hasn't been published, and we also await guidance from the regulator. And now back to Olivia.
This brings us to the end of this webinar, which forms part of this year's annual conference. Thank you for listening. We hope you found it helpful, and please do get in touch if you have any follow-up queries. If you submitted questions during the course of this webinar, we will get back to you shortly. If you'd like to get in touch at a later date, please use our contact details, which are currently displayed on screen. We look forward to welcoming you again soon. Thank you and goodbye.